Hearing the applications in the test claimants matter.
Now, Mr. Hewitt, it might be helpful if I say at the outset, we feel there's a limit to the length of time we can all concentrate on these issues. So what we would propose is that we have a short break at about 11:30, if that's going to be convenient.
Yes.
I thought the relationship was there in 16 years.
Well, I know. Yes. Yes, that's true. It's been a sustained effort for some of you for longer than it has been for us. We found the summaries of submissions that both sides have produced extremely helpful. Particularly, if I may say so, Mr. Aronson, your summary of the stories so far, it's a bit like for newcomers to the Archers. You know, you catch up on the story, and that'll be very helpful, particularly when we hear the appeals, because there will be justices who are coming fresh to this. One point we did notice is that on the table of issues that the taxpayers have produced, the third issue from the foot, which is issues 18 and 19, damages, with the thin cap point, that's not pending. That has been refused.
I think this was produced before, just before we got the order.
Right.
We received it, I think, on the day that we put the submissions in.
Fine. Well, thank you, Mr. Stewart.
Yes. My Lord, we were hopeful. I was speaking to my learned friend, Mr. Aronson. We're hopeful that we will be able to complete this morning. There's a limited amount that you can say on a permission application.
Yes.
Yes. And I wasn't proposing, for my part, certainly, to argue the merits of any of the points. No. I apprehend that what you're interested in is, first of all, the financial consequences of the various points, which is obviously of importance, and the general importance of the point.
Yes. Would it be helpful if I just... We've had a provisional discussion about all these issues, obviously, and it might be helpful if I were to indicate particular areas where we need assistance. One is, I think we've got the general picture about the computational issues. The one that struck me at least as possibly being in a different position from the others was the standstill issue in relation to Article 64. And we'd be particularly interested, I think, in knowing whether that is really a distinct issue from all the other computational issues, and just how important it is in practical terms. We're also interested in relation to under the heading of computational issues, there are two where we've already granted permission to the taxpayer, issues 11 and 12, and where we'd like to know whether those issues can be agreed or not. There's also, in relation to the San Giorgio and enrichment points, another issue 11, where we've granted the revenue permission in relation to the set-off of ACT. And again, we're wondering if that's a point that's capable of being agreed between parties rather than having to go to a hearing. On issue 13 in relation to San Giorgio, that's what seems quite an important point about the use of reliefs and whether San Giorgio is confined to actual handing over of money or is also engaged by the use of reliefs. You've asked for, if we grant permission on that, you've asked for clarification of what exactly the taxpayer's case is.
Yes.
And it might be helpful for you to explain to us a bit more about what the problem is in that regard. And there are questions about the effect of the permission we've already granted in relation to issue 28, the date, what Mr. Aronson has raised the question of whether effectively we're inviting an appeal on whether the court should depart from Climate Benson, or whether we're concerned with how you, in general, or whether we're confining this to the date of constructive discovery of the mistake. And there's a similar question in relation to issue 26A, the Sempra issue, I think, about whether that's really about what exactly is the scope of the appeal there. Again, it's Mr. Aronson who's raised a point who will no doubt expand on it. So in going through your submissions, those are the points that we had noted.
Yeah. So what I was intending to do, my Lord, was to start with an overview of how the issues, what monetary outcomes are produced by the various issues. Yep. Now, this is not straightforward because the effect of one issue in monetary terms will depend on what answer you've given on other issues.
Of course.
But what I was going to do is try and run through this as far as I could until we give you a broad idea. There are three big issues in monetary terms. The first is the Claimant-Benson point. And that is assuming that, and I did assume that you had given permission for an argument that Claimant-Benson was wrongly decided.
Yes.
That the minority should be preferred to the majority.
Yes.
And the further note, I think, which you sent subsequently confirmed that in my mind anyway, because you were asking whether we should deal with that point as a discrete point.
Yes.
And I'll come back to that.
Yes, I think we will come back to it. I think Mr. Aronson is wanting to argue that that the effect of a grant should be treated as being narrower than that to avoid a conflict with the previous Supreme Court judgment in FII. But my recollection is that the point wasn't actually argued in that case. But we'll hear from Mr. Aronson.
Yes. I think our position is that it was certainly assumed that there might be a mistake claim because, of course, two of the issues before the Supreme Court was the legislation that had been introduced to block the extended limitation period. Was that valid under European law? Mm-hmm. So it was assuming that there would be mistake claims, and there was an issue about Section 32(1)(c) and whether it required mistake to be an element of the claim. Mm-hmm. But it wasn't an issue as to what was a mistake, mm-hmm. which is essentially what we're arguing about in the Claimant-Benson. It's not. I hope this is clear. It's not saying that there isn't a mistake of law claim. Mm-hmm. It's simply saying, what is the mistake? Can you make a mistake in circumstances where, if you'd asked any lawyer, they would have told you the same thing? Yeah. Is that a mistake? When the court subsequently, 20 years later, tells you you were wrong. Everyone was wrong, in fact. So that's the point. But anyway, the Claimant-Benson point, assuming it is a point, is one of the big, obviously very important points in monetary terms. The second is what I call the Sempra point. Now, can I just expand on that? In Prudential, the Supreme Court appears to have departed from the decision of the House of Lords in Sempra. Mm-hmm. Now, what I think is uncontroversial between the parties is that the effect of the decision in Prudential is that interest on the principal sums is Section 35A simple interest, mm-hmm. and not compound interest, as Mr. Justice Henderson and the Court of Appeal had held. That I think is common ground, and as I shall explain, that has quite a significant impact on the claims in itself, mm-hmm. Because compounding over 30 or 40 years at the rates of interest that were prevalent is pretty significant. So that is undoubtedly, that's common ground. Where there is a dispute, I think, is what is the effect of that on the actual SEMPRA periods themselves. Now, what I think the revenue's position in this is, if there isn't a claim in unjust enrichment for the SEMPRA period, then there cannot be a mistake claim, because that is a claim in unjust enrichment. And the only way that the claimants can go back beyond 6 years is by invoking a claim in unjust enrichment in mistake.
Yeah, it's actually the whole point of the mistake claims.
Exactly, yes. So our position is the effect of this is that they can't go back more than 6 years. And therefore there are no SEMPRA claims, if you want to put it that way, going back more than 6 years. Now that obviously has a significant effect as well on the claims, because it would mean that they would be limited to there is now a statutory remedy. You may have seen that, which was introduced after Prudential, to grant a statutory remedy for the SEMPRA period, but it goes back to 1996. I think it's in respect of dividends paid after 1st January 1996. So it doesn't go back to 1973, which the claims do at present. So as I understand it, that's the dispute, and the claimants will argue, I think, that Prudential did not have the effect we say it did, but if it did, there is some other kind of claim that they can bring to the same effect.
Yes.
And that's quite obviously an important issue.
Yes.
Could be an important issue in the litigation.
Yes.
It wouldn't be such an important issue if the Claimant-Benson point was decided in the revenue's favour, because of course that wipes out all of the claims beyond 6 years in any event. So this is why I say it all depends on how the issues interact. But if Claimant-Benson remains as it is, then the SEMPRA point is very important.
So the SEMPRA, I mean, which issues are we talking about now on the table?
It would be part of issue 26A, which is right at the bottom.
Yes.
Simple or complex.
These are ones we granted permission, but there's Mr. Aronson's looking for clarification.
Yes, I think you also said that you were not holding the revenue to any concession we made below, which was essentially a concession that SEMPRA was the law, which obviously it was at that stage. And we understood from that leaves it open to us to argue what the actual legal position was in relation to the claimants.
But as things stand, we've granted permission. The only question is whether Mr. Aronson wants us to be a little more specific.
Yes, I think or restricted in some way.
In due course,
yes. So that's those are the first two, and then the third point is what I call the enrichment point, which is issues 17 and 18. And this is extremely important in monetary terms, because it again deals with all the ACT claims, which were not FID claims, so all the older ACT claims, and has the potential for essentially removing the enrichment so that there aren't claims.
Yes,
so that would have a significant impact financially on the claims, because in the back case and in the FII and GLO generally, there are a lot of ACT claims.
Yeah, this is the one where we've said our provisional view was that we were minded to grant, but obviously
yes.
we'll have to hear what.
Yes.
And I think if having heard, we were deciding to grant, I think HMRC accept that the claimants should have a hearing on issue 15.
Yes, absolutely. They are linked in some respects, although of course the claimants say they're different, but there's certainly a link, because they both concern the general situation where a claimant makes a payment to someone, but the recipient is obliged to make some kind of payment or pass some kind of value to someone else, and that was similarly the position in Pirelli, if you recall the case where it was held that the tax credits given to the foreign parent had to be taken into account in computing the restitution to the subsidiary. So it does all raises this issue as to what is the enrichment in that kind of situation. So it raises that, which we say is obviously an important issue of English law, but it also raises a point of European law, because that's what the claimants succeeded on in the Court of Appeal. My reading of the judgment was that they accepted that there would be a claim, that they accepted, our arguments as a matter of domestic law, but they said European law overrode that and didn't permit you to have that kind of principle of enrichment. And that raises quite important issues as to what the scope of this supposed principle of lady and kid is, which is often said to mean that you have to pay all the tax back no matter what. But we would say that it doesn't go as far as that.
Yes.
So if we take as a starting point the original judgment given by Mr. Justice Henderson, which was amended but only in a very small respect by the Court of Appeal. Now that was for approximately £1.2 billion. This was for BAT. I was proposing to talk about these, the effects in relation only to BAT. This is because we've done a lot of work on BAT. BAT is the test claimant, and so there's lots of computations have been done on BAT. It's more difficult to get figures to do these calculations for other claimants. So, and BAT is probably representative. So you start with 1.2 billion. Now, if you take account of the decision in Prudential, which, as I say, I think is common ground, and you substitute simple interest under Section 35A for compound interest, then that at least more than halves the claims, this claim. So you're down to a figure somewhere in the region of 400 to 500 million odd from 1.2 billion. The precise answer depends on other assumptions that you might make, but it's somewhere of that order. Yeah. So that is, I think is where we are at the moment. Now, if the revenue was successful on the Claimant-Benson point, this would reduce the claims considerably. It would reduce them to something in the order of about £50 million. Because that, of course, means you're only looking at claims within 6 years of when the claim was made, and in BAT's case, that was in 2003. They made their claims in 2003, so they would be able to claim in respect of approximately the final 2 years of ACT from 1997 to 1999 when it was abolished, and about approximately 12 years of corporation tax, 1997 to 2009 when the law was changed to be compliant. Now, in that case, the effect of issues 1 to 10, I'll call them. I know they're not all 1 to 10, but broadly issues 1 to 10, the computational issues, the effect of that would be a lot smaller than it would be otherwise, obviously, because we're starting with a much lower base. Mm-hmm. So the effect then would be measured in the millions rather than the tens or hundreds of millions. Maybe as much as 10 million, but it's in that kind of order. By contrast, if you start from the current position, where I was talking about around 400 or 500 million, the effect of the issues 1 to 10 would be to reduce the claims by somewhere in the region of 50 to 75%. Again, depending on exactly what. So we're talking about several hundred millions of pounds. So then turning on, if a revenue was successful on the enrichment issue, then the claims would be reduced, we think, to somewhere under £100 million. Again, it's hard to quantify that, but it would be in that region. And again, the effect of issues 1 to 10 would be greatly reduced. And then finally, the Sempra point. If the revenue are right about the effect of the decision in Prudential, then that would reduce the claims significantly, probably roughly halving the claims. Something of that order. So I hope that's helpful.
Well,
It gives you rough...
I mean, it's interesting. I mean, what is your submission as to how far we should be guided at all by the amounts at stake? I mean, it seems rather difficult to say, well, we'll grant permission if there's 100 million at stake, but not if there's 50 million at stake. I mean, the figures here are so sort of big in any view.
Yes.
I mean, what is your submission? Maybe we should simply ignore the figures and simply ask ourselves, is there an issue of general importance from a legal point of view?
Well, that's what we addressed in our submissions. That was the approach we took, and we addressed that. So I would say that is the most important matter. Yeah. Although you do have to, one other factor might be that it can affect quite a lot of other claimants. So yes. It's not just BAT and a couple of others. There are something like, I think we put the figures in, there's something like 24 others in the GLO, and then there are hundreds of others who have made Taxes Act claims under the statutory procedure.
Yes, I mean...
So that
we
is...
can't really sort of, if we're dealing with a sort of historic tax, which threw up all sorts of problems and then threw up all sorts of more problems when the European Court got involved, one's instinct is to say, well, that's the past, unless they're general points of continuing importance, yes. Then we should treat the past as the past. I mean,
yes.
I mean, if one approaches on that basis, can you say that your computational points are actually things which we should be digging around in now?
That was what we were attempting to do in the written submissions.
Yes, I saw that.
Because the dispute on there are two broad areas of dispute on the computational provision, what you call the computational issues. Actually, that may not be a totally fair categorization. What they are actually issues for determining what unlawful tax was charged and when. So it is going to unlawfulness, i.e. was this unlawful for the revenue to charge a certain amount of tax? And if it was, when was it charged? Because we're dealing with the past, as your Lordship says, and with a situation where, particularly as regards ACT, the position was not at all straightforward, because you would receive foreign dividends at what we call the water's edge, and then there would be distributions throughout the UK group over periods of time.
Yeah, but why does, I mean, I understand what you're saying, but why does that make it a point which we should be spending a lot of time now?
Well, for the reasons I think that we set out in particularly paragraph 18 of our submissions. Because of it goes to the nature of the San Giorgio remedy. Because what is being said, I think we've set this out in these submissions, but what the dispute between the parties is this. The European Court said in the second reference, CJA2, said that it was lawful to charge corporation tax to a certain extent and unlawful to charge it beyond that. and the extent that it identified was the difference between the UK rate of corporation tax and the foreign nominal rate of corporation tax. So we gave a very simple example here where the difference was 10%. Now, what the European Court appears to be saying is that the UK was entitled to charge 10% corporation tax on dividends that it received, and therefore any tax paid at 10% would be lawfully charged and paid. What the test claimants are saying is no. What they're entitled to do is to generate a credit at the FNR by multiplying the FNR by the amount of the dividend grossed up. They produce this figure, and then they say, well, they can apply that on top of anything else as a separate piece of relief. And that obviously has the effect of wiping out the corporation tax, and therefore they say it's unlawful. So really, on one level, the dispute is about what is the nature of the unlawfulness in this case.
Yes, I mean, as I understand the taxpayer's case, is the revenues case is that the taxpayer's use of the reliefs and set-offs is irrelevant. You just look at the end product. Was the tax charged by the revenue?
And paid, was it? And
paid, but was it greater than that 10%? The taxpayer is saying, well, hang on, we've used up these reliefs and set-offs, and that should be included.
And we wouldn't have used them otherwise.
And we would,
well, this is where it merges in with the argument about the reliefs. I think it really is essentially.
Which of the computational points? One thing when I read your paper, I wanted to get a guidance on which of the computational points best focuses that legal point.
Well, I think it's corporation tax issues, as we said, 1, 2, and 4, and which then have an analogue in the ACT issues, which are, I think, 5, 6, and 7. It's how you compute. I mean, these are the issues as to how you compute the unlawful corporation tax, and then how you compute the unlawful ACT. Now, I think everyone agrees that whatever method you use for the corporation tax, you use the same method for ACT, because what the European Court quite clearly said was, if it's lawful to charge corporation tax, it's lawful to charge ACT, because the ACT is a prepayment of the corporation tax. That was their reasoning in the second reference. So if you're entitled to charge 10% corporation tax on a foreign dividend that's received, you're entitled to charge 10% ACT when it's redistributed. That was what they held in the second reference. So those issues go to that. And then the other issues, I think, in particular issue 9, raises the question of conforming interpretation. I think issue 2 probably does as well.
Yes, I was going to say issue 2, that's the mixer point, isn't it?
Yes.
I mean, is that not a different
It's
point?
Probably the conforming interpretation point. I think you're right, my lord. Oh. Yeah, I think it's probably issues 1 and 4. I think it was... Mm-hmm. Exactly, and with those issues, the question really is which dividends are they talking about when the European Court talks about the dividends which are redistributed, or the redistribution of the foreign dividends. That's what they say, and of course in a simple situation you can see that, because you can see when a dividend is redistributed if there's only one dividend, but where there's a lot of companies in between, you can't necessarily determine that question very easily. Mm-hmm. What I think that what the test claimants say is, well, whatever the principled answer is, it's too complicated to do. It's essentially, I think, their case, and that we should therefore use a simple method, which is adapting the ACT system that was there for dealing with franked investment income under the domestic system. But of course, that was a system, we understand, which didn't differentiate between different amounts of FII or different dividends. All dividends were the same under that system, so it didn't make any difference. So it wasn't designed, that system wasn't designed for this kind of question. But it was there.
Yes.
But
So really, 1 and 4, and then the analogues in 5, 6, and 7 are concerned with the issue you raised earlier about whether the taxpayer's credit approach is correct or not.
yes.
The point you've just mentioned about that's the CT61 point, the one you've just mentioned, isn't it?
Yes.
That's again a distinct issue.
That's a different, yes. But that is also part of the process of determining what ACT was charged unlawfully.
Yes, yeah.
Because until you've carried out that exercise, you cannot determine what ACT was charged. That is what it's designed to do. It tells you that certain ACT, which was paid on dividends paid out to shareholders, was charged unlawfully.
Yes, yes.
And
yes, I see. So really the mixer point is to do with the blending or non-blending of dividends before we reach the UK, and the CT61 issue is to do with where there are layers of payment of dividend within the UK.
exactly, Lording, yes, precisely. And of course, similar issues to the CT61 issue arose in relation to the foreign part of the group.
Yes.
Because profits would be generated, I'm always imagining a chart at the bottom, by a trading company somewhere in Europe or whatever, and then dividends would be paid up by that company. And they would have very similar, very complicated group structures, and dividends would be coming from here and there.
Yeah.
And under the double tax treaty provisions, under the double tax relief, it was necessary to determine when that profit, which was taxed at the bottom, reached the top. Because that you could only, by doing that, you could determine what tax relief you were entitled to, because you would determine what tax had been paid, actually paid in relation to those profits. So that exercise had to be done. The difference, of course, is that it was done at the time in relation to the foreign part of the group structure. I mean, they had to go through all of that every year and ask the questions, where did this come from? What relief are they entitled to? But all of that had been done. So we have that information. What's being said is, well, it's too complicated to do it for the UK part of the group now, because it just takes too much time and too much effort. And of course, that is partly a function of the fact that we're going back to 1973. So we've got claims going back a heck of a long way. But our case is simply, well, whatever the practicalities, you may say this is an easy way of doing it, but it produces the wrong answer in principle, and so it shouldn't be adopted. But yes, it's a matter of conforming, and the fundamental point I think that we've tried to make is you shouldn't be applying a conforming interpretation. And it's quite a significant conforming interpretation, because the UK provisions have to be amended quite considerably to make this work. You don't apply that in order to determine whether there's a breach of EU law by a payment. You apply that once you determine there's a breach of EU law. That's a fundamental point. In order to cure the breach, you should apply a conforming interpretation. But determining whether there is a breach is a prior question, we would say. So that's why we say that leaving aside the monetary effect and the effect on groups of companies, why there are points of general importance. I mean, particularly important for as long as we remain in the EU.
Are we allowed to take that into account?
The conforming interpretation point, I think.
I mean, the conforming interpretation
Maybe
point is a major, or could be a major issue in a sort of general sense. How you apply it in a particular, very complicated case may not be terribly helpful, but as a general proposition, I can see it could be important, but less so if we're not members of the European Union.
Well, that may be right, of course, but of course, the terms of leaving may leave us still subject to European law.
Right.
But in any event, there are a lot of, you might call them historic, but I mean, they're not necessarily that historic, other challenges under EU law to the legislation. We gave one example, which is a case called Gallagher, you may have seen, which was in the tribunal. This concerned intergroup transfers where within the UK there's no capital gains tax or corporation tax on capital gains. It's exempt, but it's not exempt even within a group if it's a non-UK company. And the argument was that's a breach of freedom of establishment, etc. And Gallagher is the case where that's being litigated. And as I think we quoted, the tribunal judge thought that the conforming interpretation issue was the most difficult issue that he had to address in that case, because you were left with the problem, well, how do you cure this unlawfulness? And there are various ways of doing it, some of which might have led to the conclusion that there was no claim by the taxpayer, and some of which wouldn't have. I mean, it was a question of whether you were allowed to charge the tax immediately. You weren't allowed to charge the tax immediately, but what you could do is defer the payment. I think the European Court has said it would be lawful to have some kind of deferral system. But we didn't have a deferral system, of course. So the question is, well, what kind of deferral system could you conjure up under conforming interpretation, if any? And
that's the Judge Bear's
Judge Beer,
Gallagher. What's happened to that? Is that moving up the system?
I imagine so. I don't know. Yes, it will be being.
But I mean, you get into all sorts of difficulties. I mean, that's a problem once you start having to redraft your legislation,
Yes.
speculate about how it should be done.
Yes, and if you just look very briefly at what Judge Beer said about it, just a few paragraphs. It's tab 36 in the authorities bundle. And it's paragraphs 212 to 218, which is on MS page 1472. It's nice to have a computer-free hearing, I'll say.
Yes.
Sorry.
Remarkable piece of judgment for the first tier, but
Yes. Well, occasionally you get that, but in these paragraphs you can see he's attempting to analyse the case law on conforming interpretation and impose some kind of analysis on it. But I would suggest it's a controversial analysis.
gosh, and the hearing ended on the 1st of February and he produces by the 25th of March. Lesson to us all.
We had a
And is this because he's trying to work out what tax might lawfully have been charged? Is that what he's doing?
yes.
Right. And is that the correct approach in
Well,
principle?
that's
Rather than simply saying, was a tax lawfully charged? If not, you grant a remedy.
yes. Well, that I think just makes my point that there's something that needs to be perhaps dealt with.
Yeah.
He mentions routier, of course. There are issues about conforming interpretation in the routier case, which I think some of your lodges may have sat on. I don't know.
I mean, it's sort of Wilkes United Dairies, isn't it? You know, if the tax hasn't in fact been lawfully charged, I might have thought that was an end of. You don't have to worry about what might have been charged.
Yes. Well, that used to be the position. Yes. But European law makes it more complicated. And certainly, I think Mr. Anderson would agree, if you went back to the 90s, the decisions of the European Court were much more blunderbuss than they became later. They were more Article 43 precludes legislation of this sort, full stop, and that was the end of it.
Yeah.
But now you get much more nuanced decisions like FII,
Yeah.
talking about foreign nominal rates, and Marks and Spencer's talking, no possibility of using the losses, etc.
Yeah. Yes.
That seems to be the trend.
Well, I suppose is the thinking that it was all charged by authority of statute, and it's only rendered illegal to the extent that it's unlawful that it's incompatible with EU law, and so you have to work out what EU law would have permitted in order to work out the difference.
Yes, I think that's right, and that's why there's an issue in this case as to whether, not just what it would have permitted, but what it demands. I suppose that's the question. Does EU law demand that they be granted a tax credit on top of everything else, or does it demand something else? Because we would say you can't give a conforming interpretation. You can only give a conforming interpretation insofar as EU law demands something.
Yes.
I think Judge Beer's talking about a discretion, which we would disagree with. That there are cases where the court's got a discretion to decide how to apply a conforming interpretation. So I hope, my Lord, that answers your question about what we say about the importance. But
Yep.
I don't think you can ignore the amount of money that's at stake, particularly, I suppose, when it's public money.
Yeah.
But I'm not relying on that as being the only the critical factor. As regards issues 17 and 18, we've also set out that they're different because they are, of course, the question of unjust enrichment. And I hope we've set out in our submissions why these are, that there's at least one, if not two, points of general importance in relation to those issues. Your Lordships raised the question in your most recent note as to whether there might be some mileage in dealing with the Claimants-Benson point first as a discrete point. I think that was what's being said in there, and then
What was in our mind was that if we're having a second look at Claimants-Benson, we really ought to have an enlarged panel to deal with that. But we don't need an enlarged panel for all the other points.
no, exactly.
So if it was practical to have separate hearings, then that would be advantageous from the court's perspective.
Yes. Well, certainly from the point of view of the argument, it's a very discrete point. It doesn't depend on understanding to a great degree the complexities of ACT or corporation tax or any of the other points. It is obviously a point of English law of unjust enrichment. And we think, the revenue, if the other side agree, we think it could be heard comfortably within a 2-day hearing. And therefore, hopefully, fixed earlier than a much longer hearing would be. Yes. The problem, well, as with all preliminary points, you've got a balance. Obviously, if the revenue were successful on the point, it would greatly simplify the case, and it would probably lead to a re-evaluation by the parties as to what was worth arguing about. Because you would then get down to a very small, well, not small in absolute terms, but relatively small amount of dispute. On the other hand, if you decided that Claimants-Benson stood, then we'd simply have potentially wasted some time, assuming that the further hearing would be delayed by having this hearing. So it's a matter of judgment. But I can certainly see the point that you wouldn't want to have a large panel hearing all these other points.
Yes.
And yes, as I say, I think it's possible to be a reappraisal. You asked about the youth point. I think I might leave that to Mr. Ernson to explain what the importance of that is. We don't know what the significance in monetary terms is. Just as a matter of background, to remind you that these points were the youth point and the unjust enrichment issues 11 and 13 were argued in the first Court of Appeal. That's going back to 2010. And at that stage, we hadn't carried out any computations at all. Certainly we hadn't, and I don't know if the taxpayers had. We were dealing at that stage with points almost of principle. So I don't think we've ever been aware of what amounts might be at stake in relation to the youth point. It only affects, I think it's right, corporation tax from 2001 on their case to 2009. And it's corporation tax on non-EU dividends. So that's the significance of the standstill not applying. And similarly, on the unjust enrichment issues, 11 and 13, we don't know what amounts are at stake or what significance it has in monetary terms at all.
Yeah.
And what we're not very clear about, and this is the point we made in our submissions, is exactly what case the taxpayers or the claimants are putting. If you had a chance to look at the Court of Appeal decision, you would have seen that there was a number of different, what they were called constructs produced of different alternatives. But of course, it's one thing to say you're making a claim in unjust enrichment for the amount of the relief at the time that you used it. It's quite another to say you're going to assume that the relief carried forward and would have been used at some other time, and therefore you would have paid less tax later because you wouldn't have used up the relief at the time when you thought you had lawful tax, but in fact you had unlawful tax. That's quite a different argument. And if you remember, we were having similar kind of arguments in the context of ACT in Prudential. Because, of course, the ACT issue was originally just part of 11 to 13. It was part of one issue. Mm-hmm. They were saying that the same applied to ACT, to capital allowances and to group relief and whatever. And it was only because we lost the revenue lost on the ACT issue that was brought forward and dealt with in Prudential, and the other issues remained because the taxpayer had lost on those, stayed. But the similar kind of issues arose, I think, in Prudential as to, if you recall, as to what precisely the claimants were saying about the ACT. Because there we had lawful ACT, didn't we, which was being set against unlawful corporation tax.
Yes, we were hopeful that, we indicated in the order in April that because the ACT point has effectively been dealt with in Prudential, we were assuming that the parties would be able to reach an agreement on what the effect of that was in this case.
Of ACT, I imagine we can, yes. But what we can't agree on is what the effect is on the other reliefs issue. Because I think that the claimants would say those are different.
Yeah. Yes. Yeah.
I quite accept that they do raise interesting and possibly important issues. Although we'd like to know exactly what they are, as we say, precisely what they say. If you look at the pleadings in BAT, you just find a claim for reliefs. No details as to what exactly they say happened, what they say the nature of the claim is. And I think the other point that your lordships raised was issues 11 and 12, where
Yes.
permission's been granted. I think I'm fairly confident in saying that issue 12 could be agreed, because that is absolutely on all fours with the decision in Prudential.
Yes.
What I'm not able to say at the moment is precisely what the effect on issue 11 is.
Yeah.
And that can be an important issue, because just to be clear, what we're talking about here is, once you've decided that there was unlawful ACT paid, you then have to ask the question, well, when, if ever, was that ACT set off? Because that's the other complication in this whole case, that some of it was set off and some of it wasn't. And you have to know when it was set off, because in order to then work out what the restitution is. So you have to identify that. And of course, there was no identification at the time, no differentiation between unlawful and lawful ACT. Nobody knew it was unlawful. Now, what happened quite often was that the ACT was paid at the top level. The reason for that is you could carry surrender ACT downwards within a group, but not upwards. So you only paid it at a lower level if you knew you could use it, I think, at the lower level. But generally, it was paid at the top level. It would either be used by the company that paid it, or, very commonly, surrendered to other companies, and then they would use it. So that raises another issue as to what was being surrendered when you surrendered some ACT. How much of it was unlawful, how much was lawful? And then you have the issue as to when it was used by the company it was surrendered to. Because it had its own ACT, of course, possibly as well. And so that's what this issue, I think, is about. How do you identify what's said, what is being utilised at what time? It's possible we may be able to agree. I'm afraid we haven't done the work on that yet.
Yeah.
It was an interesting issue because it didn't feature in the Court of Appeal's judgment at all. Although I think it's right to say there was an appeal by the claimants on it to the Court of Appeal, I don't think it was ever raised in an argument. So it was only before Mr. Justice Henderson that it was sort of argued out. But I hope that deals with all the issues that you wanted us to cover.
Yes, that's all very helpful. Thank you.
Unless there's anything else, I think that's all I would have to say for the time being.
Yeah. Mr. Aronson.
These are lordships. We take the computational issues first. They've virtually all been dealt with already. I'll explain why. Your lordships have refused permission on issue 6, which was the conforming construction adopted by the Court of Appeal in 2010. I'll explain the significance of that. And the parties are agreed that issue 12, which dealt with that esoteric point in Prudential of the carryback of ACT in the same year, where foreign dividend, where you have foreign credits in the first quarter, what can they be set against? That actually sets out the conforming interpretation in practice. There is nothing in any of the revenues points of significance that remains to be determined by this court. Let me amplify those provisions, those submissions. Let's deal first with issue 6. My learned friend says, what is a conforming? How you conform domestic legislation is a jolly important point. Well, it's important in any given case, but there's no clear single answer that applies to every case. But the general approach is the same, which is you try to make the UK tax rules work in an equivalent fashion where you've received, where foreign dividends are received, to the way in which it works where domestic dividends are received. That's the overarching principle. I can take your lordships through the passages. All three of your lordships are in Prudential, and I'm sure you remember that's how you start. You say, well, what's the purpose of the exercise? Foreign dividends have been dealt with in a discriminatory way. You've got to deal with them in a way as closely equivalent as possible. In the Court of Appeal in 2010, HMRC argued that the way you did that was that you had applied a conforming interpretation to section 231. 231 is the section that gives the tax credit. 231 only gave a tax credit in its terms in respect of UK source dividends. So you give that credit in respect of overseas source dividends to the extent that overseas tax is paid. That was the decision. That was the Revenue Zone argument. It was accepted. We said, no, it's too complicated. You should disapply the whole thing, just treat it as franked investment income. We lost that point. But this was a close fallback position for us anyway. It's almost the same thing, not quite, but it's almost. Treating it all as franked investment income could have given a windfall in certain circumstances. That's why it was not accepted. They sought permission to appeal against that. That's issue 6. Permission has been denied. Turning now to Prudential. In your lordship's own judgment, you deal with the operation of the conforming construction at the very end of the case when you're dealing with the carryback. And what you do is you take section 231, you give the foreign dividend a credit, and that credit is then set off against.
Can we just have a look at that?
Yes, I will take you to it.
Or you're going there anyway.
It's really rather important. It's been dealt with. It's
Tab 35.
Authorities 35, tab 35. Can I take you through very briefly to your opening passage? Authorities 35 at page 1355. Paragraph 18. If you just look at the last sentence, 4 lines up from the bottom, there are of course differences between holdings giving a degree of control and smaller holdings, but it's not obvious what the relevance they have to the question of the central issue on this appeal. That is the proper treatment of domestically sourced and overseas sourced dividends so as to avoid unfair discrimination between them. That's the central point. The issue you were there dealing with was the revenues argument that portfolio dividends somehow have to be treated different from other dividends. And then, if you come to the key passage, the form of credit is in paras 112 to 119 at page 1387. I'm not going to take through the whole of it, but it's fairly short. If you go to 1387, it's issue 5b asks, where domestic FII was carried back to an earlier quarter, is it to be regarded as having been applied to relieve lawful and unlawful ACT pro rata, or only lawful ACT? Go to para 115 on page 41. You'll see that in this appeal, Prudential renews the arguments which Mr. Justice Henderson favoured. The UK tax system was unlawful because credits were not given under section 231 for tax on overseas source dividends in order to relieve an ACT liability. So that's always been our argument. you should get a credit for overseas dividends the same way. The use of carried back FII to relieve unlawful ACT deprived Company A of the credits which it should have had for the overseas source dividends. The carried back FII should therefore be regarded as having been applied to relieve only lawful ACT. HMRC's answer in their written case is exactly the point my learned friend is trying to make here, is that EU law does not mandate a form of credit for overseas source dividends. They quote the statement of the CJEU in paragraph 72. I don't think we need to read that. HMRC unexceptionally interpret this statement as meaning that it's lawful to charge ACT on a dividend paid by Company A only to the extent that it was lawful to charge mainstream corporation tax on the profits out of which the dividend was paid. But HMRC go on to say that the relief required was not in the form of a credit, which was the equivalent of further FII. And now the decision of this court. We do not accept HMRC's submission on issue 5B for the following three reasons. First, it follows from the answer we've given on issue 1 that we reject the contention that no particular form of credit is mandated by EU law. What the CJEU said in paragraph 72 of its second decision must be construed in the light of what is said in paragraph 61 to 65, which you quoted in paragraph 26 above. That in turn falls to be understood against the earlier ruling of the CJEU in the first hearing, which we've quoted in paragraph 7 above. In other words, EU law requires a tax credit by reference to the foreign nominal rate to which the profits of the overseas company have been subject. As a result, the UK can charge ACT in relation to Company A's dividends so far as they comprise profits from overseas source dividends only to the extent that there is tax due in respect of those dividends after it has given Company A that tax credit. Secondly, the consequence of this is that PAC is correct in its contention that HMRC's approach would result in depriving Company A of the tax credits on overseas source dividends which the EU law mandates. And then it goes on to work through the arithmetic which proves it. And what this point is done and dusted. It's the same argument that Revenue are trying to raise now, that somehow you have to find in the ether the illegality, and then, and I think they actually say it in somewhere in the 11-page or 12-page document, that somehow you then have to find something in the UK legislation which you conform. It's all been done. From Mr. Justice Henderson to the Court of Appeal in 2010 to this court last year. Section 231 is the provision that needs to be conformed. So if this were to be a matter of general importance, and I'll come to that in a moment, it's dealt with. The Revenue have no arguable case. A similar point goes to the mixing issue. If ever there was an esoteric question, that is it. But that's dealt with by Section 801. Section 801 tells you how you mix overseas credits. And all you do is you feed into that overseas credits as required by EU law. So you conform Section 801. My learned friend says we're putting the cart before the horse. We're not. The horse has 4 legs, and the 4 legs is what's been dealt with here. The cart simply follows it. So nearly all these computational issues have already been dealt with. Are they significant?
Sorry, so you say nearly all, looking at your list, which ones are covered by this submission?
I think what is not covered by it is the question of withholding tax.
For which?
Withholding tax.
Number?
Oh, Lord.
Sorry, I mean, I'm
not very good at numbers, I'm afraid. Anyone?
Well, I know, but they're your numbers, so we...
Yes.
There seem to be, yeah,
I think it's 4.
4 seems to deal with it in relation to, is it in relation to, is that, I thought it was ACT, but maybe it's not, maybe it's mainstream corporation tax, and 6, is that the same issue in relation to the other tax? Yes, in relation to ACT, yeah.
So your submission covers everything except those?
I think it's everything except withholding tax. I'm just going to check. I think that is. Right, and the withholding tax issue, with great respect, is again unarguable. It's something
Yeah,
provided.
but I mean,
Yes,
that's a
yes,
separate point.
It's a separate point. Yes.
So you're saying all these computational points are really covered by, in principle, by what we said in Prudential.
And your refusal of issue 6, which is the basis of what you said in Prudential. I'm not saying you were following the Court of Appeal. You were applying what the Court of Appeal itself said in 2010. That issue 6 is the conforming interpretation as applied by the Court of Appeal. That was to conform section 231.
You say we refused issue 6?
Yes.
Yeah, it's a different issue 6.
Different issues. The issues are 6 and the first.
That's issue 6 of the first, yes.
Yes, I mean, getting these numbers right.
I know, yeah.
Right.
That eliminates most of the tedious stuff, which has taken an awful lot of working by people to have to go through the computations all over again on the basis that somehow you're going to conform some other section as yet unidentified. It's not arguable at this stage. UFTs is a different issue. These were the changes to the way in which credit was given for overseas tax, introduced in the Finance Act 2001, if I remember rightly, but I think came into force in 2001. Take what my Lord Reid said, we're dealing there with what goes on overseas, the various streams of dividends. Previously, all dividends, as a matter of practice, tended to be routed through mixer companies in the Netherlands, because that's what Section 801 envisaged, that you would do that, and then there would be a blended rate. The Revenue changed those rules, made them much stricter. There could be no blending overseas. They could be blended in the UK in certain circumstances, but a lot of types of dividends could not be blended at all. And it had the result of tightening the credit rules. Is it significant? Yes, it is, because it applied across the board, not just to dividends from the EU member states, but from dividends outside the EU. That's why the standstill provision was argued to apply and held to apply by Mr. Justice Henderson and the Court of Appeal. But if they've got that wrong, then the taxation of foreign dividends under Case 5 of Schedule D was unlawful from 2001 onwards up to 2009. Now, why do we say 2009? Because that was the year in which the United Kingdom actually abandoned the credit system and went on to exemption. The credit system simply wasn't working efficiently. And the UK abandoned it, and there is, in effect, exemption applied to all dividends. Now, we say the point is plainly arguable, because with great respect, Mr. Justice Henderson and to the Court of Appeal, they got it completely wrong. The standstill in Article 64 only applies if the change in the law, which was introduced in 2001, either ameliorated the position or didn't change it, and was based on the same approach. That's the settled jurisprudence of the EU. And the whole purpose of the UFT provisions was to change the basis and tighten it. At that stage, when the Court of Appeal heard this case in 2010, they didn't have the benefit of the second reference to the ECJ. In the first reference, the ECJ said, they revised it, that there was nothing wrong with the credit system as applied to non-portfolio dividends, to 10% plus dividends. There was nothing wrong. You got a credit, and that was sufficiently equivalent. It was only on the second reference that they changed that and said, yes, there is. The credit system doesn't go far enough. It doesn't give you enough credit. But what happened in 2001 was that you got even less credit. So it unquestionably was not an amelioration. So is it a matter of general importance? Yes, in that in the normal run of tax cases, issues that apply across the board to all foreign dividends right up to 2009 are pretty current. I know it's 10 years ago, but it takes time for cases to actually get to court. We're dealing with a lot of dividends, not just in this GLO, a lot of dividends across the board. There are many companies who have received foreign dividends who, subject to whether they can make a claim in time, mistake, etc., or whether they have made statutory claims, can get their D5 tax back. How much, I don't know, obviously. But is it a point in itself of significance? Yes, it is.
And, am I right in thinking that it's a discrete point?
Yes.
There's no question of having to consider what might otherwise have been done, for example, by keeping to the older blended system. If the UFT rules are contrary to EU law, that's it.
If the UFT rules are contrary to, or if the UFT rules remove, the introduction of the UFT rules remove the standstill,
yes,
then you're simply back on the basic principle for all foreign dividends, whether from the EU or otherwise, and we know how they're to be dealt with because that's Section 231, etc. It's all been dealt with. Well, that's dealing with the ACT, but as far as the D5 tax is concerned, well, we just know you get a credit. Credit at the FNR, we just know it. That's nothing to decide. There are computational issues, I think it's 11 and 12, where you have granted permission, but you're assuming, I think you've granted permission, you're assuming the parties can agree. So I suppose my submission comes down to, insofar as you're granting permission, it should be for those matters where the parties can agree in the light of prudential, those discrete points, but should refuse on all other computational issues. UFTs to one side, on the basis that they have already been fully dealt with by the highest court, and there's no arguable case for HMRC. And being historic, it's very questionable whether they had any public importance anyway. Told we've sent computations on issue 11 to HMRC several months ago. We haven't heard back. We assume it should be agreed. I mean, the guidance is pretty clear. It's a small detail. So much as I'm loath to deprive your lordships or even a larger panel of the intellectual interest in these computational points, my submission is that they are not matters that should be heard. Can I turn to the matter which you would love to hear, but I say you should not, which is Kleinwort-Benson?
Presumably on the ones you say we're hoping you might agree on, the logical thing would be for us simply to defer the question of leave.
Yes.
Hope to do rather than grant permission, which might suggest there's more than we think is justified. Yeah. Right.
I learned from Mr. Rabinovich has this expression, he says, the court would gag to hear this one. These points, this is a gagging point, something which the Supreme Court would just love to get to grips with, Kleinwort-Benson and so on. In the first hearing before the Supreme Court, where we were dealing with the nature of the mistake claim, he thought that was something which would really excite the court, and I left it to him. Whether it did or not, I don't know, but it didn't.
May I politely ask you to keep your voice up?
Yes, yes, I'm
I
sorry.
find it's fading.
And there are people at the back too who may be interested in this.
Right. What I say to that is, this is something that warrants being dealt with by a larger court. It has, in this case. That was the first Supreme Court hearing. First Supreme Court hearing concerned sections 320 of the Finance Act 2003 and 107 of the Finance Act 2007, which statutes purported or attempted to restrict the mistake remedy in cases of tax. They were struck down in the case of 107 because it was overtly retrospective, confiscatory. In the case of section 320, it wasn't, but there wasn't any transitional period. It was introduced in a cack-handed way. Simple as that. The whole purpose of the hearing was to determine whether HMRC...
Sorry, which hearing are you talking about now?
First Supreme Court hearing in this case.
It's
back in
FII 1
2012.
SC,
Yes. FII 1. Not some abstract...
No, but I mean, I need to be...
Yes.
Was I in this one?
Yes,
Is it in the bundle here?
it is.
Yes, I mean, you know, I don't have instant recall of everything that I've been involved in over the last 7 years, even in this case.
Yes.
It's tab 25, I think.
Tab 25.
Yes. Of this panel, I'm the only one who wasn't there.
That's right.
Oh, I see.
No, I don't think you. I don't think Lord Carnwath
Oh,
was.
good. That's
Oh, no, he wasn't there.
No, I think I'm.
Oh, you
You're the only
weren't?
one.
I'm the only survivor.
I know.
Oh, I do apologise. I thought you were. No,
I
quite-
may
no,
have been
no.
sort of present somewhere.
No, yes.
Was I even in the court then? I'm not sure.
Yes, you were the only remaining judge.
No, you weren't. I don't think it was.
2012, February
The
2012.
hearing was in February.
Never
20.
mind.
Okay. I do apologise. Lord Reid was, and Lord Reid. My
Yes,
Lord,
I remember it quite
You,
well.
you wrote a long,
Yes.
I think it's a judgment in
Yeah.
the Supreme Court. HMRC's basic claim, basic argument in that case was that there were two remedies, the mistake remedy, Kleinwort Benson, Deutsche Morgen Grenfell, and there was the Woolwich remedy. Woolwich remedy was adequate to vindicate European law rights, and therefore the mistake remedy could be removed by Parliament without infringing the principles of effectiveness or legitimate expectations. That was the Revenue's basic case. Inherent in that case was that there was a mistake remedy. If ever there was an opportunity before a full panel of the Supreme Court to argue that there was not a mistake claim because the mistake was common amongst taxpayers, it reflected prevailing practice, that was the time to take the argument. They didn't take the argument. They accepted that in principle, as a matter of domestic law, there could be a mistake claim, but it wasn't protected by EU law. My lords, in 2013, this court heard an important development in the Henderson and Henderson line of cases, Virgin Atlantic against Zodiac, which my Lord Carnwath was in. This was the case of a patent case where Virgin Atlantic sued Zodiac for infringing their patent on an aircraft seat. They won in the English courts, but after their success in the English courts, the European appeal system declared that the patent was invalid because of prior art. And then the question arose, well, you've got a decision of the UK court which says the patent was valid and that Virgin Atlantic had a claim. But here you have the European appeal mechanism declaring in rem to the world that the patent was not valid. And the case arose, question arose, could Virgin Atlantic recover its damages? And that led to a very long exposition by Lord Sumption, with whom all their other lordships, including Lord Carnworth, agreed. Just a long examination of the Henderson and Henderson principle. Was this res judicata? Was this cause of action estoppel? Was it issue estoppel? Was it an abuse of process type issue? All these points were thrashed out. And the upshot was they said that because none of these estoppels are absolutely absolute, if I can put it that way, that isn't the language used by the court, that's what I'm saying. There's a little wiggle room in all of them, and that must apply in a case where damages are sought in respect of a patent which ex hypothesi, because of what the European appeal system had declared, that patent never existed. That point could not have been raised at the English court's hearings. It couldn't have been raised because the patent did exist at that stage. It hadn't been declared invalid at that stage. So if you were to look at that case, you will see the examination of Henderson and how it's developed through the years. But the principle that is laid down is that whether it's a cause of action estoppel in the same case or an issue estoppel, if the point could have, with reasonable diligence, have been argued, then all material issues that arose in the first case, or could have arisen in the first case, should be taken in the first hearing.
Sorry, I mean, I was in that one, so
Yes.
I have some recollection of it. But I mean, are you, my colleagues, I don't think were, but are you trying to say that because of the sort of abuse idea as developed by Lord Sumption and Lord Newburgh and those things, we should knock out at the permission stage any attempt to reopen those in a tax case?
No, not in a tax case. What I'm saying...
Well, in this case.
In this case...
Because the revenue had the chance to take the point before.
That was the occasion we were arguing.
No, I mean, that's what,
yes,
but that's
absolutely,
what you're saying.
Absolutely. I'm not saying...
Even if we think it's a point of very wide public importance,
yes,
way beyond even the interests of the revenue,
yes,
then we shouldn't take this opportunity to...
Well, yes, and can I amplify the point, not just by raising my voice, to show that this really matters, but what was the other point in the first Supreme Court hearing? And that was whether Section 33 of the Taxes Management Act, which was the statutory method of seeking redress for a mistake, was inapplicable. Why was it inapplicable, held to be inapplicable? The Court of Appeal said it was applicable because you can mallease it. Decision of the Supreme Court, you could not mallease it. Why? Because one of its cardinal features was that Section 33 didn't apply in cases where the mistake was consistent with prevailing public practice. The very issue which the revenue now seek to raise, to say, well, Kleinwort-Benson was wrongly decided, you shouldn't be able to claim a mistake when the mistake represents the prevailing practice.
But I mean, those are points you would obviously be arguing with great vigour at the substantive hearing. They don't mean it's not a point of general public importance.
I accept there are points of general public importance, but it's raised judicata. It can't be raised here.
I see.
In this case, this is the second hearing at the Supreme Court. The first hearing was to deal with the mistake remedy. So I'm not saying it's unimportant. Of course it's important, but it was dealt with by a panel of, was it 7 or 9 in the first hearing? 7.
Yeah.
It was dealt with, and it could be dealt with in the future in other cases. It needn't be a tax case. I'm not saying it's not, if HMRC want to raise it, maybe they've got some other case they can raise it in, but not in this case. It's terribly important. As you said, it would just sort of literally decimate the claims here. But these claims started in 2003. This is the first time we ever heard about it. It was after the prudential hearing. It wasn't taken in prudential, it's never been taken. But in this case, we've had a Supreme Court hearing. It would make a travesty of the Henderson approach. And although my Lord Hodge wasn't in the Virgin Atlantic case, my Lord was in a very recent case. Was it Factile? Was it what it called? I forget.
I have been dealing with Henderson recently.
Takar and Bracefield Developments only decided in March, where all this was examined again. So I just say there is no arguable point on which HMRC can succeed in this case on Kleinwort-Benson. I would happily join the audience to watch another case and hear it argued. But I would very unhappily have to argue the point in this case. What can I do briefly with Sempra? I know you said break, but in fact, I'm almost at the end. Or would you like to take the break and we can?
No, by all means. If you're not proposing to take very long over Sempra, then we can proceed.
I wasn't proposing to take very long. I'd say that the issue here is whether your Lordship has given permission on the Sempra issue, and your Lordships have said that you release HMRC from their concession. Your Lordships did that with respect without hearing argument as to whether the concession just can be released like that. And what I would ask is that at the substantive hearing, if there is to be a substantive hearing on Sempra, that we should be permitted to argue that even if as a matter of principle or for other cases, not this test case or the case for which it is a test case, compound interest should not be awarded for the Sempra period, or interest should not be awarded for the Sempra period or whatever, that HMRC must be held to their undertaking, their concession in this case. Your Lordships in Prudential excluded that case, but that's just happenstance. Prudential came first. What if this case had come first? I'd just say it would be unjust. Where a concession has been made, HMRC had never at any stage sought to argue that for the Sempra period between the payment of ACT and the set-off of ACT, that interest was payable. They've never sought to deny that. That in this case, despite your Lordships having given permission, we should have the right to say that permission can be given so that you can give an argument in a decision in the abstract, but it should not apply to this particular case and to the other 23 cases for which this is a test case. So it's really just asking for clarification as to whether we will be permitted to argue that. As I say, the reason for that is it's just happenstance as to which case came first in the listing.
Mm-hmm.
Whereas I haven't dealt with the enrichment, so maybe it would be appropriate to
Very well.
take the break. And then
Yes, we'll have an adjournment for about 5 minutes.
Well, listen, I just add one thing I forgot to mention on the mistake issue.
Yes.
The date of the mistake. It has very little significance. If I can say that.
Sorry,
It has very little significance.
yes.
At the moment, the holding of the Court of Appeal was that it's the date of constructive discovery was the first decision of the ECJ or CJEU in 2006. The Revenue have argued that it should go back to 2001, which was Hurst, the first sort of bombshell, as I think Walker described it. It doesn't make much difference. These claims were issued in 2003, so it's in time anyway. Whether this would be an appropriate case, assuming your lordships are with me, obviously I'm only making that assumption for the purpose of this point, assuming your lordships are with me, that you're not going to hear the Klein-Walk-Benson point, is this really the time to decide whether Lord Brown was right in DMG, that it's the date when you realise you have an arguable case, as opposed to when the mistake is there to be identified. At the moment, the majority in DMG said it's when the mistake...
Was it just Lord Brown?
It was only Lord Brown, yes. I'm not saying just in the sense of
No.
dismissively, solely Lord Brown.
Carries a great weight, isn't
Yes,
it?
yes. So is this an appropriate case to revisit that in the abstract when it actually has very little impact?
Mm.
Can I turn back to UFTs and say that one point that if your lordships were to give permission on UFTs, it would be important to have permission also on the question of other reliefs. The point my learned friend says we haven't particularised, and that is because UFTs only applies to D5 corporation tax on the dividend itself, nothing to do with ACT. And in most complex groups, there are bucket loads of other reliefs that can be set off almost automatically.
Which issue are you now addressing then?
That's a very good question. I think this is...
(11 and 13).
So for some companies, very little actual tax would have been paid at the time, but losses would have been carried forward or group relief would have been made virtually by the computer. It just would have been done because that's how the system was set up. That's what is expected. We say that where reliefs would automatically be used, then the use of those reliefs and the loss of those reliefs is something that directly flows from the breach, and so is the subject of a restitutionary claim as a matter of EU law, because that's the division.
I'm sorry, just to clarify, we've granted permission on issue 11, and the question is the cross appeal on issue 13, is that right?
Well, we've granted the
Revenue on issue
it's under heading San Giorgio, and we've granted the revenue permission on 11 in respect of ACT.
Yes.
And what's pending is BAT's application under issues 11 and 13
13,
in respect
yes.
of a release.
Yes, and so you're saying we should grant that?
Well, yes, if you grant permission on use, this is really important because this, we're told that for bats, we believe there's 331 million's worth of reliefs that were used against the D5 tax that arose on foreign.
And is that resisted? I can't remember.
Well, Mr. Ewart was really wanting further embedded particulars.
Yes, which
I didn't understand it be resisted very strenuously in principle.
No, absolutely. I didn't argue. I don't think I argued that. In that case, it was argued by some erstwhile colleague who I think had 4 constructs. Is this the 4 constructs?
Yes.
No, but I mean, if the question is,
Yes.
if we're going to grant permission on issues 11 and 13,
We will particularize.
both ways, then you were going to particularize.
We will particularize, yes. In a way which hopefully will be intelligible. So may I now turn to the restitutionary issues. And while I completely recognize that the nature of the English law restitutionary remedy is something of general interest that isn't confined to this case, my submission is it's unnecessary to hear and decide those questions because the EU law on this is quite clear. That's the lady and kid point. But unless there's going to be a 4th reference to the CJEU, if there can be a 4th reference, it's very hard to see how HMRC can persuade this court that lady and kid does not apply. But there's a second point. The restitutionary point, the Pirelli point, if I can call it that, has already effectively been dealt with by the refusal of permission on issue 6, the conforming construction. Because once one applies the conforming construction to the overseas income that comes in, to the overseas dividends, so that they carry a credit, the tax system itself provides whether or not ACT needs to be paid, whether there's an excess of franked payments over franked investment income, and that operates completely independently from any credit that is given to the shareholder. It's already been determined by the operation of section 231, which then brings into effect section 241, which tells you how you use the credits to frank your dividends. The credit given to a taxpayer follows automatically, and furthermore, in the eye of EU law, the credit given to the shareholder, reflects the underlying corporation tax paid in Europe. That's the whole basis of the Court of Justice's jurisprudence. That the imputation system is effectively carrying the underlying corporation tax charge and giving a credit for that which ends up in the hands of the shareholders. It's all been dealt with. Pirelli was a totally different case. Pirelli was a case where the companies concerned had made a group income election under section 237, if I remember rightly, it might have been 247. The effect of making a group income election, which was a group election by 2 companies, was to take the dividends outside the franked investment income system. It took it outside. There was no credit. That was the choice. You paid your dividend under a group election no credit, but also no ACT, or you paid it without a group income election, there was ACT and a credit. So it's understandable why the House of Lords in Pirelli decided that that credit should be taken into account. There's no application whatsoever to this case. So although the English law for restitution is interesting, whether it needs further development after ITC, where it's had a very extensive hammering, if I may put it that way, it's really been not done to death, as Boris Johnson might say, but it's certainly been given a very good outing. Whether it's necessary to have a hearing just to deal with the English law side in a case where we say there is no arguable case to prevent EU law requiring a restitutionary remedy to be given. It just has to be given. And that also comes through in the prudential case in 3 places where you point out that interest has to be paid on the prematurely paid ACT as a matter of EU law. That's the Saint-Georges remedy. It has to be paid. It's got to be recovered in some way. Why is interest paid? It doesn't matter whether you analyse it as a matter of debt. Interest is payable because the ACT, in respect of which that interest is calculated, was unlawfully charged. It's all down to the same thing. There was a mistake in paying the ACT. It all just follows. So while I can understand HMRC looking for some conceptual argument which, were it to be accepted, would decimate these claims, so this has all been argued. I mean, we won on these points. And so we won on these points in the first Court of Appeal. In the second Court of Appeal, they're unquestionably right. So whether the English law point is a matter of general importance, in the context of this case, it has no significance. HMRC cannot recover as a result of succeeding, if they were to succeed, on the English law arguments. That's why that meant to be 10 pages, but it turned out to be slightly more. I said, these aren't English law restitutionary issues, these are Sempra. Sorry, these are Saint-Georges and restitutionary issues. Colleague behind says, I haven't dealt with whether there should be 2 hearings or 1. I suppose I'm really saying there should be none, but if there is to be 1, it's to be on a very few points.
Sorry, I can't hear that.
If there is to be a hearing, it should just be on the few points which do require attention. The separate hearing for Kleinwort Benson, yes, but not in this case. Unless I can assist your lordships further, those are my submissions.
Thank you very much indeed, Mr. Aronson. Mr. Yard.
Can I deal briefly with the major point that my friend made? First of all, he said that the computational issues had all been determined already by the Court of Appeal in 2010. And
the guidance given by this court in Prudential is also
exactly
relevant. Yeah.
But we say, as we've always said, that our case is not inconsistent with what the Court of Appeal decided in 2010. The Court of Appeal in 2010 were addressing the question, what do you do where there's an unlawful charge of ACT? And how do you negate that charge? And their answer was that you conform Section 231 so as to provide a credit of a suitable amount to get rid of the unlawful charge. But what they weren't addressing was the question of how do you decide what the unlawful charge is? That was something that wasn't being considered in 2010. It was considered in the second stage of the litigation, which is why there was another stage where computations were being done, and we were trying to determine what the answer was on the facts of the BAT case. What you've got to remember also, and this is something that's a bit of the archaeology of this case, but in the 2010 litigation, at that stage, the revenue were arguing that it was only dividends directly paid and received that were taken account of. And if ACT was paid by the company which received the foreign dividend, then there would be a question of unlawfulness. But there wasn't unlawfulness necessarily, or certainly not of the same sort, where there were payments up the group under group income elections. And that was one of the issues which had to be referred to the European Court on the second reference. I think my learned friend in his description, in his notes, goes into that one of the issues before the European Court was what we called corporate branches, I think, argument as to how it applied. So in 2010, we were looking, as had the European Court of Justice the first time round, we had been considering a very simple model of two companies, essentially, a foreign company paying a dividend to a UK company, which then paid a dividend and paid ACT. If you read the first reference, the judgment of the European Court, you'll see it's all framed in terms of that very simple situation, which is why we had to have the second reference. So there was nothing in the 2010 litigation that was intended and did cover that situation. Of course, once you determine that there is an unlawful charge of ACT, then you have to perform some conforming interpretation to get rid of that charge. And that's where perhaps Section 231 comes in as regards ACT, certainly, because that's a provision that provides for a credit against ACT, so under the domestic system. So I would submit that neither in Prudential were you considering this question, how you compute the unlawful ACT. You were also considering there a question of what happens when there is unlawful ACT or unlawful corporation tax. And that seemed to be my learned friend's main point. So I think we would say that isn't an impediment to these arguments. Turning to the mistake claim. My first point I would want to make is, as I said in opening, we accept there is a mistake claim, a mistake of law claim. The question is, what is the nature of a mistake that founds a mistake of law claim? Now, this point could not have been argued in the previous first stage of the litigation. And the reason for that is the way that this litigation was structured was, for better or for worse, where we had a reference to the European Court, which was the first reference. At that stage, nothing had really been argued about. We simply, along with Mr. Justice Park, we tried to think of what questions we should ask the European Court. Because at that stage, we didn't have any idea what they were going to say about the lawfulness or otherwise. So questions were raised. The matter came back before Mr. Justice Henderson, and a whole series of issues were agreed. And you can see that if you look at either of the judgments. This is where we get issue 11, issue 1, issue 1.
Yes.
There was a list of issues, legal issues, that were agreed, were litigated. And they were litigated before Mr. Justice Henderson, and then there was an appeal to the Court of Appeal, and then there was a further appeal to the Supreme Court on some of the issues. But this was not one of those issues. And it didn't arise in any of the issues. So it wouldn't have been open to, it wouldn't have been relevant, put it another way, for the revenue to say, oh, by the way, Claimant Benson was wrongly decided.
But surely, when you agree the issues, purpose is to limit the scope of this particular litigation. And so you can't then come back later and say, oh, well, I'm sorry, I wish we'd put that one in.
But except that the litigation was envisaged and was conducted in 2 stages. So a number of issues were listed.
I see what you say in relation to this particular case. There were always going to be other issues.
And there were, yes, there's a whole lot of issues. You can see that the 2016 Court of Appeal decision, there are a whole list of issues. We know that. You can see that from this list of issues. There were about 28 issues on the second time we went round. And one of those issues was the date of constructive discovery. And what we say is, it's a necessary part of our argument on constructive discovery that we deal with Claimants-Benson. Because once you accept Claimants-Benson and this kind of artificial idea of a deemed mistake, then the date of destructive notice that was held in DMG, in a sense, logically follows. If you assume that you can make a retrospective kind of mistake, then, of course, there is some logic in saying, well, you only discover that mistake once the court has told you that you've made this mistake. Because, in fact, the mistake didn't exist, in a sense, until the court told you that you were in fact wrong. So it's necessary.
But I mean, you'd accept, presumably, that if the court is opening up the Claimants-Benson argument, in general, is open to Mr. Aronson to argue at the substantive hearing that actually in this particular case it should be limited by the background as he has argued.
He can argue that, yes, I'm sure he will, as to who it would apply to if it was decided. Yes, and I don't think there was anything in the grant of permission that precluded that being argued. The most that they could say is, well, we could have agreed it as one of the issues the first time round, which I'm sure is true. But there were a lot of issues you can see to deal with, and so so it's not an issue estoppel situation. And of course, it couldn't have been argued anywhere but the Supreme Court at any stage. It's not an issue we could have argued before Mr. Justice Henderson. The Section 33, the prevailing practice issue, was quite different. Whether it's logical or not, the European Court treats common law decisions of the court differently from statutory decisions. So they're quite happy with the court saying, actually, we were wrong, the common law was actually something else. That's not, as far as they're concerned, you're not changing the law because they apply the normal fiction of you're just discovering the law, etc., which is the principle that they apply themselves to their own judgments. But they do not allow states to change the statute if it contravenes EU law. So there's no question of there being a problem for this court to say, well, in fact, the common law took a wrong turning in Claimants-Benson, and in fact, we think it's something different. That wouldn't contravene EU law. But if the government were to pass legislation that said Claimants-Benson is wrong, that would contravene or potentially contravene EU law. And that's why there was the issue about Section 33 and prevailing practice in the first time round. And then my learned friend raised Sempra and the question about releasing us from our acceptance below that we were bound by Sempra. Now this was argued out in the written submissions. You may recall that you were sent, I think there were, it's behind tabs 11, 12, 13, 14, and 15. There's a whole series of written submissions, including very detailed submissions behind tab 12 by the claimants on the Sempra issue. That's paragraphs 38 to 43, making exactly this point that we shouldn't be released from the undertaking, what we'd said before, and whatever the law actually is, it shouldn't be applied in this case. So these points have all been made. You can see they're very detailed.
Yeah, sorry, where does this take you?
Well, my
All
learned
he's
friend,
saying is he should be able to argue that whatever we say about these points in general, they shouldn't apply in this case. And presumably he can argue that.
well, except that there has been an order made. I mean, it's part of one of the order.
I see. Which order?
This is the order.
This is for the avoidance of doubt.
Yes,
Provision, yes.
Where was this?
it's
The 8th April 2019,
Yes.
and it's the final paragraph.
Yes.
and my point is that was made in the
Oh, I
light of
see.
very detailed submissions made by both parties on this question. So it's not a question they haven't the opportunity to argue it. They did argue it.
Yes.
Yes, but that allows you to withdraw the concession, but and therefore pursue the permission to appeal. It doesn't mean that at a hearing the claimants can't say, notwithstanding the withdrawal of the concession, the appropriate outcome in this case is such and such.
If there is some legal reason why
If
that
there's
should be the
legal
case.
reason why.
No, I quite
Yes.
accept that.
Yes.
Quite accept that.
So in a sense, it's a non-point in that respect.
Yes. And then finally, I think my learned friend dealt with the enrichment question, and he said it was determined by Lady and Kidd. Well, you've seen we don't agree with that. We say that there is a substantial issue to determine whether, in circumstances where a taxpayer pays an unlawful charge, but as a result of the legislation, exactly the same amount is paid to his shareholder, whether European law would demand that they should be returned the unlawful tax, assuming that English law of unjust enrichment would say that there is no enrichment in that circumstance. And we would say that's a very important and very arguable point.
Oh, European law or domestic law?
Well, there is a point of domestic law first as to what the law of unjust enrichment is in that kind of situation, and whether there is an enrichment. That's a domestic law point.
Yes.
And I think everyone agrees that on its own is an important point.
Yeah.
But there's also a point of European law as to whether, even if that's right, I think what the claimants say, even if that's right as a matter of domestic law, somehow European law overrides the rules of unjust enrichment to demand that you be repaid all the tax. And it is a pretty startling proposition, in a way, at first blush.
But it's one which might be irreparable.
Could be, yes, if we're still in the EU.
Can I just mention, in relation to Climate Benson, that just the way you put it just now, treated the declaratory theory of common law decision making as also carrying with it the idea that the common law never changes. Now, if you think about it, logically that would mean that the common law today, for example, prudential, that was a law in 1189. And, that's what Lord Reid called a fairy tale.
Yes,
And
exactly, yes. And that's not the basis on which the declaratory theory...
so maybe more subtle accounts of the declaratory theory of a common law than that.
Yes. No, there are, yes. I think it's a matter of policy, broadly, that...
But you're saying that's the way the European Court looks at it.
Well, the European Court, I think what they accept is that courts can change the law
Yes.
in the sense that they can
Yeah.
declare it to be different from what it
Yes.
was,
Yeah.
and that's not a problem.
But it doesn't have the same consequence as the statute law.
Exactly, yes.
That's saying nothing about its effect in domestic law.
No.
Yes, all I'm getting at is that there may be, at any rate, an argument that, that courts can develop the common law, and that a decision in 2019 doesn't mean to say that the law declared in 2019 was necessarily the law in 2000 or 1719.
I think that realistic view is generally the view that's adopted. I think Lord Hoffman, in the context of the mistake claims, in fact, I think in DMG, said, well, if it makes people happier, you could describe it as a deemed mistake, because he recognised the law actually had changed.
Yeah.
It wasn't what it was thought to be previously, but you would still regard it, the person as making a mistake.
Yes. Yes. So I think if you go back to people like Hale, the idea was that it was declaratory in the sense that the judges were declaring a sort of collective wisdom in the legal community. I think, rather which needn't necessarily, which would be capable of evolution.
Exactly. Well, the fact that the common law can develop in the sense of when social norms change shows that it isn't fixed and immutable in 1189 or whenever. Yes.
Yeah.
I think that's all I had to say. Just on the youth point, I mean, I do think I do find it, standing back from it, quite difficult to see how this is a point of such great importance. It only applies to these cases. I mean, it's a point as to whether it's not a general point on the standstill law, because that's quite clear. It's a point on how it applies to the particular factual situation when we introduced the youth system, and so it's hard to see how it goes beyond in any way that very narrow factual situation. Whether there's a lot of money at stake, that may be the case or may not. As I say, we don't know. So again, I think that's these are my submissions, unless I can help you further.
Thank you very much, Mr. Stewart. Well, the court is really very grateful indeed to counsel for the clarity of their submissions, and also grateful to those behind them who've been involved in preparing this. Also, it's an extremely complex case, and it's one where the court really depends on counsel for assistance, and we've received that assistance, and we're grateful for it. We'll consider all that's been said, and we'll let you have a decision as soon as we possibly can.